Welcome to Employment Law This Week. I'm George Whipple. Our top story, a California appeals court rules that employers must accommodate workers associated with a disabled person. A delivery driver for Dependable Highway Express requested a route that allowed him to administer dialysis for his son at night. After this request was denied, the driver refused his assigned route and was fired. The former employee sued, alleging disability discrimination under California's Fair Employment and Housing Act. While the trial court ruled in favor of the company, the Second District Court of Appeal reversed the decision. The court stated that, unlike federal law, the California statute requires employers to provide accommodations based on an employee's relationship with a disabled person. Matt Goodin has more.
What the court has effectively done here is say that an employer has a duty to provide, for example, time off or leave to care for a disabled person that the employee is associated with. That would ordinarily be something that would be required under the California Family Rights Act, and employers with less than 50 employees don't have to comply with the provisions of the California Family Rights Act. But because the FEHA, the Fair Employment and Housing Act, applies to employers with only 5 or more employees, what the court has effectively done in this decision is impose obligations under the California Family Rights Act to employers with less than 50 employees. It has created now a duty on employers to provide reasonable accommodations to employees who need to care for a disabled family member or practically anyone, really, because the court hasn't defined, this limit of association. So it could be a friend, it could be a roommate. It really has expanded that broadly.
A wireless company's class waiver provision violates the NLRA. That's according to an administrative law judge who cited the NLRB decisions in Murphy Oil and D.R. Horton. Rulings which rejected arbitration agreements that bar class or collective actions by employees. The judge ruled that, even though federal appeals courts have challenged the legality of the NLRB's position, he is bound by the board's interpretation unless and until the Supreme Court rejects it. The ruling could set the stage for the Ninth Circuit or D.C. Circuit to weigh in on the NLRB's interpretation, which has already been rejected by the Fifth, Second, and Eighth Circuit Court of Appeals. So far, with very limited exception, the board has refused to yield, now routinely invalidating arbitration agreements with class waivers. The NLRB splits on employer conduct rules. A hospital in Michigan must change rules that regulate interaction between employees. Among other things, the hospital's rules barred negative or disparaging comments of employees or physicians. The board found that, while the rules do not expressly prohibit an NLRA-protected activity, they restrict relationships and interactions between employees, which could restrict federal labor law rights. One board member dissented from the finding, arguing that the current test could result in neutral work rules being declared unlawful. He called for a new test that considers not only employee rights, but a balance of legitimate employer interests as well. And continuing the legislative trend we reported on last week, California's governor has signed a new policy to expand the state's paid family leave law. The legislation increases benefits to 60% of wages, capped at around $1,100 a week for 6 weeks. It will take effect in 2018. Finally, it's time for our tip of the week. Jessica Hodkinson is here with advice on best practices for avoiding risk during the employee life cycle.
Best practices for avoiding employment claims can boil down to 3 major points. 1 is documentation, 2 is no surprises, and 3 is treat people with respect. It's really important that you document everything with respect to an employee's performance, discipline, and if there's any sort of investigation involving the employee, that is properly documented. Second, no surprises, which really ties to the first point. You need to document, but you also need to talk with your employees about what your expectations are and where they fit with respect to those expectations. And finally, treat people with respect. This is the most important from my perspective. Treat people with respect during the application process, during the onboarding process, while they're an employee, and if for some reason they're leaving the organization, whether voluntarily or involuntarily, always treat people with respect.
Thanks, Jessica. That's it for Employment Law this week. Thank you very much for watching, and we'll see you next time.